Welcome to Employee Termination Tips. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, I want to talk about pay statements and how they relate to your termination and decisions you should be making in relation to your termination and your actions with respect to your former employer. Now, your pay statement is that document, oftentimes emailed to you electronically, that you get every 2 weeks or so at the end of a pay cycle, that breaks down all the components of your biweekly pay. And if all you're seeing in that pay statement is a base hourly wage and your vacation pay, your general holiday pay, it might end up being relatively straightforward. Now, the problem comes when you get complex pay statements. Those are pay statements where you get all sorts of different additions from premiums, allowances, bonuses, employer contributions to this, that, and everything else. So if you start seeing that kind of stuff, the reality is that you're probably looking at a situation of underpayment by your former employer. And although it's not 100%, the fact of the matter is that payroll is very difficult to do. And especially where you have larger corporations that have headquarters outside of your jurisdiction, so outside of your province or state, or even outside your country. This can be very problematic. The same also applies even if your company is based only in one province or state, but payroll might well be determined in part by payroll specialists from another province, state, or country. And I know this sounds a bit crazy, but this is the reality of stuff. On top of the fact that every jurisdiction has its own employment standards legislation, and the rules are very complex. They might seem straightforward, and they probably are straightforward, but nobody tackles them appropriately, and nobody recognizes properly the discrepancies between jurisdictions. And yes, I find that hard to believe, but the reality is that there is not enough work done, and it's probably because these organizations are so large, and they divest the role down to the payroll department. Lawyers aren't typically dealing with it. Accountants aren't even typically dealing with it. So interpretation is not being done properly. Payroll specialists or payroll people have a limited function, and everybody pushes off responsibility to somebody else. And that's the way it works. So what happens? Nobody knows really what's being done, or they know one set of rules, but those set of rules might not necessarily apply to your jurisdiction and yourself. And what does this mean? Well, it means that you could very well have been underpaid for a significantly long period of time. And you got to find out whether or not that is the case. Because if you got the right lawyer, it's very easy for that lawyer to take that complex pay statement and determine whether or not there has been an issue with respect to payroll and underpayments. It isn't rocket science, but it's something that is very rarely, in my professional experience, done. Because everybody is so focused on the back end. Everybody's focused on termination pay, severance pay, and they don't fully understand the roles and the rules pertaining to payroll and payments. And they simply let it pass and accept what has been accepted. And they clearly don't understand all the pertinent statutes and rules governing it. They pull pieces here and there, but they don't understand the core aspects oftentimes. And because of this failure, nobody addresses it. And if they ever have addressed it, it is always covered up in confidentiality agreements, settlement agreements, non-disclosure agreements, releases, and the like that lawyers present to be impenetrable. from the employer's standpoint. Because if they made a serious error with one person, it probably causes an error for everybody else. So what they do is they try to lock it down, close it down, and be done with it, and keep it under the carpet because nobody else has picked it up. And for most hourly employees, especially where these incidents occur the most, well, for them, they're out there in the field, they're working, they're slaving away. They're not payroll specialists to start off with. They're not sitting in an office. They don't have the tools to discern whether or not they're getting underpaid or not while they're working. And on top of that, they don't want to lose their job. Because as soon as you challenge something like this, what happens? You're on the first person to be chopped from the company. So nobody challenges it while they're working. You can only really challenge it when you've been terminated. And that's when confidentiality agreements come in, non-disclosure agreements, settlement agreements come in. But people are so focused, once again, on the back end part that they rarely look at these other issues. And it's these other issues that are critical. And it's stuff that nobody properly looks at or nobody properly disputes. Because especially if you've been working for 10, 15, 20 years for the same company, that amount of underpayment can be quite significant. And you can't know until you've actually worked through the documentation, broken it down, and discern what the implications are. And from a legal perspective, identifying these problems is particularly important because, as I said, if it relates to one person, it probably relates to many more people in the company. And hence, the value behind that proposition is that you have significant leverage in that now you've discerned underpayments that are applied company-wide. And by having that leverage, if you know how to use it properly, and that depends on your lawyer, you can effectuate it to optimize your results. Because remember, you're the one who's been underpaid. You're the one who's been terminated. So you have to have your rights protected, your rights advanced, and protect your financial well-being. And if there's something that's clearly owing to yourself, that is important to yourself to assert and to use as a basis for your legal challenge. But the thing is, you need to know what to be looking for, how to work with it, and have the right legal counsel who understands and can direct you through the process and present it effectively. Because complex pay statements, especially where those pay statements are with big, large companies, because they have lots of money and they have lots of exposure, often breed situations, especially for hourly employees who've been long serving, to challenge their former employers upon their termination. Because what I've seen and what I know is that it's very easy to make mistakes and nobody's focused on it. Like, nobody. And that includes payroll specialists. They oftentimes don't fully understand what they're doing. And I hate to say that, but it's a reality. So if you've been recently terminated, you work for a large company, you work an hourly basis, especially, even salary, but more so hourly, and you've got a complex pay statement, you really need to address that with a lawyer who understands what they're looking for. Because there's a lot to it, and you don't want to be leaving money on the table unnecessarily when you have a potential advantage with respect to your former employer to deal with your now terminated job and protecting your financial security going forward. Thank you.